President, I rise this afternoon to address the National Defense Authorization bill that is under consideration. Will be probably wrapping up this week. And at first I want to address an amendment that Senator Corker and I have filed. It is an amendment that is related to the topic at hand, which is our security, because it is an amendment that would restore to Congress the authority to have the final word on the deployment of tariffs, taxes on American consumers when purchasing goods that originate overseas, tariffs that are imposed with the justification that our national security depends upon it. These are often referred to as the Section 232 tariffs because that is the section of trade law that authorizes these tariffs. The short version, Mr. President, is I think we ought to be having a debate and a vote on whether or not this responsibility that the Constitution clearly gives to Congress should be restored to Congress. It's my view that it should. Senator Corker and I have sought a vote on this. It appears at this point that despite bipartisan support for this amendment, we may not be able to have a vote, but I think we should. And I think we should seriously consider continuing debate on the National Defense Authorization Bill until such time as we're able to address this important amendment. The other amendment I want to discuss is an amendment that I have filed and which will get a vote. It'll get a vote tomorrow, and I'm going to urge my colleagues to support this. But let me start by reminding my colleagues something that I hope we all learned a long time ago, and that is the very, very first provision of the United States Constitution after the preamble, the very first operative portion of our Constitution, Article 1, Section 1 states, and I will quote, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives." I can't think of a more clear, succinct, and straightforward and unambiguous way to make the point that writing laws is the domain, it is the responsibility of Congress. Well, Mr. President, in the course of writing laws, sometimes we delegate some of that authority. Sometimes we delegate it to our staff. We ask them to do the drafting. We're still responsible because we're members of Congress. And sometimes we delegate it to the executive branch, and we call that rulemaking. We authorize the relevant agencies or cabinets to develop the rules that will implement the legislation. But I would argue strenuously that is still part of the legislative function. And as such, it's a delegation, but it should not be an abdication of our responsibility. Congress should accept the responsibility for this rulemaking, and we should be accountable for it, because that's part of our job. So that brings me to the Defense Authorization Bill, specifically Title 17. There's a section called the Foreign Investment Risk Review Modernization Act. What this is a dramatic expansion of the authority given under existing law to CFIUS. CFIUS is an acronym that stands for the Committee on Foreign Investment in the United States. So there's this big expansion of authority that CFIUS gets, and part of the way in which this bill, this underlying bill in the National Defense Authorization Act, part of the way that expands CFIUS's authority is by a huge delegation of legislative authority. It grants the administration enormous discretion to develop the rules by which this expansion of power will be implemented. Now, let me explain just briefly what CFIUS is all about. CFIUS, this Committee on Foreign Investment in the U.S., is charged under existing law with reviewing foreign investments in America. Foreign-based companies that wish to invest in an American company, if there is a national security concern involving the investment, if there's a risk that's identified, then CFIUS, this committee, is charged with recommending that the president block the transaction if it's considered to be a threat to our security. And under existing law, the president has the authority, in fact, to block such a transaction. So, for instance, if a Russian company were going to attempt to purchase Lockheed Martin, a big defense contractor, a big supplier of very important, sensitive, and advanced military equipment to our armed services, armed forces, on such a case, CFIUS would take, I think, a pretty quick review of that and recommend a no, and the president would almost certainly block such a transaction. So we understand there's a sensible need for this committee to exist and to do its work. So let's get back to the underlying legislation before us. Under existing law, under current law, the range of transactions that CFIUS can review for this purpose of determining whether it's a threat to our national security is pretty narrow. It's fairly narrow. And I think there are legitimate concerns that it's too narrow, especially considering aggressive and even hostile acts that are taken under the auspices of the Chinese government to acquire sensitive American technology. So, as I say, there's this delegation of authority to broaden that. And I would argue that this rulemaking, the decisions that CFIUS will make as it implements and develops these rules that we're going to empower them to develop, that's really going to decide which kinds of transactions will be permitted to go forward and which ones will not. The rulemaking, not so much the legislation itself, but the subsequent rulemaking is going to really set the scope of CFIUS review and their process. Let me give you a couple of examples. There are many, many rulemakings required of the CFIUS committee by this legislation. A couple of examples is passive investments by a foreign-based entity, a passive investment in a U.S. company, is meant to be excluded from CFIUS review. So that would be allowed, that would not be subject to the review. But guess what? CFIUS gets to define what constitutes a passive investment. That's a pretty big power. A second example is a critical infrastructure and technology company. Those are the companies that we're concerned about, right? Critical infrastructure and technology companies are the ones that have sensitive technology that we might not want to fall into hostile hands. And so that's the category in which there's an automatic trigger for a CFIUS review. Well, guess what? CFIUS is going to write the rules to decide what constitutes a critical infrastructure and technology companies. I don't know what they're going to conclude. I'm pretty sure if you're a manufacturer of a chip that goes into a very cutting-edge military application, that almost certainly would be a technology company we'd want on the list. But it says critical infrastructure. What about a power company that produces electricity that feeds into our grid? What about a company that provides water, municipal water supply? What about a supplier to one of those companies or a consultant to one of those? I think you could ask a lot of interesting questions about what kind of companies ought to qualify, and we've delegated that. That'll be decided by someone else. That'll be in the rulemaking process. Then there's the case of for whom a transaction must submit a form to CFIUS, must go under CFIUS review. And there's some criteria in the legislation, but then the final catch-all is that the CFIUS will have the authority to require these reviews for other transactions as it sees fit. What could be more broad and sweeping than that? So basically, CFIUS can itself decide to write the rules in such a way that they will have the power to review any transaction they want. So this is really remarkable in terms of how much power is being delegated to the executive branch to write these rules. And so the rules could be written in a way that they're written too broadly. And if they're too broad, it could have a chilling effect on foreign direct investment in the United States, which is a huge source of jobs and economic growth. When foreigners bring their capital to the U.S. and invest it here because America is one of the most attractive places in the world to invest. On the other hand, if they write these rules too narrowly, it could be that CFIUS doesn't have sufficient authority and transactions that we ought to be blocking don't get blocked because the rules were written too narrowly. Mr. President, there's no member of the Senate who can know in advance whether or not the rulemaking is going to strike the right balance. And that's what we need here. That's what we want. What we want is the right balance so that we're stopping the transactions from bad actors, but permitting the transactions from harmless sources that will help our economy. So, since we can't know in advance whether this rulemaking will be done in the appropriate fashion, why wouldn't we insist on the responsibility of overseeing this and, in fact, having the final say to make sure that this is done properly, that the right balance is struck? In fact, isn't that our responsibility under the constitutional authority and responsibility given to us? So this is what my amendment is all about. What my amendment simply does is it would require Congress to approve the major rules, not every last rule, but all the important major rules that CFIUS would develop pursuant to this legislation that we're probably going to pass later this week. And Congress would have to approve it before it could go into effect. It would be approved by a simple majority vote. It would not be subject to a filibuster. There'd be a strict time limit, so Congress would have to respond quickly when the rules are finished. And if Congress were to reject one of the rules, CFIUS can modify it so that we get to a conclusion. My amendment does not give Congress the power to consider individual transactions. That shouldn't be our domain. And it doesn't authorize Congress to review every rule, as I say, only the major rules, which is to say those which would have a big impact on our economy. So what are the practical consequences if my amendment were to be adopted, Mr. President? It would simply ensure that the administration would work with us as they were adopting the rules. Knowing that they needed to pass these rules in the House and the Senate, they would consult with us and say, hey, here's what we're thinking in terms of how we define critical infrastructure and sensitive technology. Here's what we're thinking about what should constitute a passive investment. And all the other dozens of cases where they would be making big decisions, they'd run it by us. And we'd have a dialogue, and we'd get to a place where there's an agreement. That's what would happen. And actually, that's exactly what should happen. Now, I've heard some concerns expressed about my amendment. Some have said, well, wait a minute. If you get your amendment passed, Congress will never approve of these rules. I couldn't disagree more. Congress is about to vote overwhelmingly. We voted in committee unanimously to grant CFIUS this broad new authority. The members of this body overwhelmingly think that we should broaden the range of transactions subject to CFIUS review. Why wouldn't we support sensible rulemaking that would allow CFIUS to do what we've asked them to do? So I think it's extremely implausible that Congress wouldn't support this. Others have suggested, well, you don't really need this because you have the CRA, the Congressional Review Act, as a mechanism that allows you to repeal a rule if Congress doesn't like it. Well, the CRA wouldn't work in this case at all because the CRA requires the president to sign a bill repealing a recently passed rule. What president is going to sign a bill repealing a rule or a regulation that his administration just passed? The CRA works when there's been a change of administration. So when the Trump administration came in, working together with Congress, the president and we repealed a number of regulations from the previous administration. But a president isn't going to sign a law repealing his own regulations. So I want to appeal to my colleagues, and maybe for different reasons, to support this legislation. For my Republican colleagues, 39 of us are co-sponsors of the REINS Act. The REINS Act would require congressional review of every regulation throughout the entire government. Every time a major new rule is passed under the REINS Act, Congress would have to vote before it could go into effect. If the REINS Act that 39 of my Republican Senate colleagues have co-sponsored, if that were the law, we wouldn't be having this conversation because this rulemaking would automatically come under the jurisdiction of the REINS Act. It would automatically require that major rulemakings would come back for a vote. So I can't, for the life of me, understand why any Republican who supports the REINS Act wouldn't support this, and I hope all of my Republican colleagues will. But I would appeal to my Democratic colleagues as well for the simple, fundamental reason that this is our responsibility. We should accept the responsibility that the Constitution assigns to us. That's number one, first and foremost. But also, let's be honest, a big majority of our Democratic colleagues voted against confirming several of the members of CFIUS. A big majority of Democrats voted against confirming the Treasury Secretary, Secretary Mnuchin. They voted against confirming Attorney General Sessions. They voted against confirming Secretary of State Pompeo. Those three individuals are on CFIUS, and the Treasury Secretary is the chairman of it. So if my Democratic colleagues had such serious reservations about the work product that would come from these individuals that they voted against confirming them, you would think you'd want the opportunity to have some say on their work product. That's what this is about. So I can't imagine that my Democratic colleagues would take the position that they must not have any say over the Trump administration's rulemaking. They've never suggested so much confidence in this administration that they would want to forego that opportunity. So I would hope that my Democratic colleagues would join me in this as well. Look, Mr. President, what this comes down to is I think we should accept responsibility for the work that we do and the work that we delegate. And let's make sure that this really important and necessary expansion of CFIUS authority is done right. And the way we do that is we make sure that Congress has the final say over the rulemaking. I urge my colleagues to support the amendment, and I yield the floor.